Can you tell the business owners watching or listening, generally what are the most common factors that hold up a transaction from a diligence standpoint?
It's usually one of two things. It's usually a third-party relationship. So if you have a lease, or
we've been through that before.
We've been through that before, yeah. So if you have a lease with a third-party landlord who really doesn't care that you have a deal going on, in most instances, you'll either need a consent or some other, a release or something from that, depending on how you're financing. Unless you might need a waiver or a collateral access agreement or something. So something that's going to impact, you're going to need a signature from the landlord for.
And they have no motivation.
And there's no motivation
right.
to do it. And if they are motivated, in a lot of instances, they may want to renegotiate or, charge a fee or,
right.
So the sooner you can get out in front of those issues, the better. So you're not trying to negotiate that at the 11th hour when you're trying to get a deal closed and you've got 9 zillion other things that have come up. Right. So that's the one. And it's landlord's a perfect example because we've been through it and it's more common than not. But there's others too, right? So there's other third-party contracts where you need a consent or you need somebody else at the table that, while you and the buyer are motivated to get the deal done, the third parties typically aren't. Mm-hmm. So they're on their own timeline. And similarly, if you have a government contracting relationship or a material permit or something like that where you're dealing with a government agency or a quasi-government agency, they also aren't typically very motivated to get things done and take a long time to get things done. So again, you want to get out in front of that and understand that on the front end.
What else can a business owner do to best prepare themselves for the legal diligence process? Because you had mentioned it could take 2 weeks, it could take 4 to 6 weeks, it just depends on how prepared that business owner is.
One thing that makes a lot of sense is to go out and do your own diligence process, when you have time. So take one of those diligence lists, go through it, try to make sure you understand what is being asked of you, and that you've got things that are responsive to that, and the things that you have are all complete, signed, all the exhibits are there. I can't tell you how many times we've gone through a process, and it turns out that, a major contract that they were marketing as being an important piece of the business isn't signed, isn't complete. Those are all things that a buyer's going to look at and say, hey, that's great that you think you have this contract, but legally speaking, you don't.
Yeah.
And, as a result, we're going to ding you on purchase price. Another terrible example of that is intellectual property and IT. I can count 3 times in the last 18 months where we had a major piece of IT come up as not being owned by the company that they thought they owned because they didn't read their contract, they didn't go through the right process on the front end, and they had an in-house developed proprietary software that turned out that they didn't own it. And we went through the diligence process, and all along the sellers, in all 3 instances, we know we own that, we own that, we own that, we own that, and then relatively short amount of time prior to closing, we found out that they didn't, and it caused a major headache. And
did it crater the deal at all? Or did it still get
almost
done?
cratered one. It delayed it extensively until we could negotiate with the third party who did own the IT to get ownership to the company, which cost a lot of money, a lot of time. And in the other 2 times, one time there was a significant holdback, and then the other time there was a significant reduction in purchase price.